I think there is a skill to written advocacy. I think a lot of people still these days write quite badly. You could you can know all the law, you could even know all the facts, and still not be able to write it down in a way that's persuasive and readable. One thing that people I think are quite poor at doing is writing a 10 or 20 or 50-page document which can keep you awake till the end. And given, as we all know, that these pieces of written advocacy, this goes in arguments and written submissions, are often the very first thing the judge reads. I think you do have to get their attention and keep their attention all the way through the document, and that I think is important to get right. I'm not a fan, however, of making the document contain everything. I don't want it to replace what I have to say, and so I am a big fan. I've always been a big fan of short submissions. We have a big pressure from the judiciary in this country to keep these things short, and that's because they don't want to wade through hundreds of pages of documents. But from our perspective, the advocacy perspective, it's also in our interest to keep it short. I think there is a fear in the profession that if you don't say everything, you might lose the case or you might forget it. I think you need to suppress that fear as an advocate when you're doing written advocacy, and make sure that your written document is just a series of signposts and tweaks the judge's interest enough to be able to ask more. I mean, let's face it, we're writing these things for an audience of people who have the same training and background as we do in our legal cultures. The judges have done our job before, so they're not stupid. They will understand that, and I think sometimes more is less. And you can say, well, there's this case and there's that case that I think you should look at, and there's this fact and there's that fact which is relevant, and therefore the conclusion is the other. But you don't have to spell out in laborious paragraph after paragraph every step of that legal reasoning like you might do in a textbook. And I think that's always the risk with advocacy: writing too much and trying to include it and then boring the judge, or making it so long they don't read it at all.